Hello everyone. Today my partner Tilman Müller-Stoy and I will discuss the FRAND objection against the enforcement of standard essential patents. This is still one of the hardest topics in patent law, and the Federal Court of Justice has now issued its first decision on that topic since the Orange Book standard decision. But before we go into the details of that new decision, let's take a quick look about how the instance courts deal with that FRAND objection. Tilman, if you represented a client that wants to enforce a standard essential patent, which venue would you currently choose and why?
Yeah, that's a good question, Jan. I mean, there are several factors which play a role for choosing the right venue, but in SEP cases, it currently seems to be quite clear, even prior to the decision of the Federal Court of Justice, Mannheim and Munich have positioned themselves quite eagerly and developed a reputation as being SEP owner friendly. They recently started to require that the license seeker must seriously engage in licensing negotiations. It's almost a must now that the license seeker also provides for a counter FRAND offer. Otherwise, the FRAND defense could go nowhere. I'm a bit interested how the new decision of the Federal Court of Justice might now play out at the Düsseldorf courts, but maybe you have some view on that.
Right. Well, Düsseldorf positioned itself differently from Mannheim and Munich. They applied the different obligations in a very strict sequence. So they, first of all, only looked at the license offer by the patent holder, and only if they found that to be actually FRAND, then they looked at the reaction of the alleged infringer and looked at whether they provided a counteroffer. So that made it more difficult to enforce a standard essential patent because you first of all had to fulfill that requirement of providing a FRAND license offer.
And of course, I mean, the license seeker could criticize each and every bit of the FRAND offer of the SEP owner and therewith escape, so to say, from injunctive relief.
And that is what's happened in practice.
So Jan, the Sisvel versus Haier decision is the first decision in a long time of the Federal Court of Justice on FRAND matters. I mean, we all remember the old Orange Book decision of many years ago. In 2015, we had then the decision of the Court of Justice of the European Union in the matter Yahweh versus ZTE. But it would be very interesting to hear your summary on the Sisvel-Haier decision. Maybe you can give us your thoughts.
Sure. So maybe just as a background to the case, as you said, it was Sisvel versus Haier. Sisvel asserted a standard essential patent. Haier raised the FRAND objection. And in the earlier instances, the courts were divided. The regional court in Düsseldorf rejected the FRAND defense. The Haier regional court accepted the FRAND defense. So the case ended up at the Federal Court of Justice. And there the court ultimately rejected the FRAND objection because the court found that Haier did not sufficiently declare its willingness to take a license. And I think there are two more general decisions or findings of the Federal Court of Justice on the FRAND objection. One is the Federal Court of Justice applies a more general view of the conduct of the parties in the negotiations. They don't look at the obligations in a strict order, as Düsseldorf used to do it. So they don't look, first of all, only at the offer, then at the reaction. They look at the behavior of parties in the negotiations in an overall assessment. And the second is that the infringer, the presumed infringer, really has to be active in the negotiations, has to show that it is determined to conclude a license agreement.
So if I understand it correctly, the Federal Court of Justice seems to want to have real-life, serious negotiations like they are done in practice.
Yes, I think this is really what the decision shows. They want to reflect how negotiations work in practice. What was your first reaction to the decision, Tilman?
Yeah, first of all, I agree with your findings fully. However, I do think there are a couple of broader aspects which are worth mentioning. One is that, in my mind, the Federal Court of Justice tries to strike a fair balance between what is being discussed as hold up on the one hand and hold out on the other hand. Another aspect which is worth mentioning is, in my view, that the Federal Court of Justice is trying to further harmonize European patent law. They do make an express reference to the decision Unwired Planet of the UK High Courts by Judge Bösing, and basically cite one of the key phrases there, which says, generally speaking, the presumed infringer must be willing to take a license on FRAND terms, whatever FRAND terms are. Jan, one remaining question obviously is that decision, Sisvel Higher, the end of the FRAND discussions in Germany, or are there maybe some open issues which remain?
Well, I'm sure it's not the end, especially since the circumstances of the case played a very important role in the outcome of the Sisvel Higher case, because the behavior of Higher was ultimately the reason why the Federal Court of Justice rejected the FRAND objection. So I don't think it will be the end. There are many questions left that need to be answered. I do think that the decision provides a certain guidance, not only to the general approach to the FRAND objection, but also for the individual obligations of the parties. There are several remarks, several comments by the Federal Court of Justice that specify how certain obligations need to be understood and applied also by the lower instance courts in the future. We have prepared an IP report about the new decision by the Federal Court of Justice that is available on our website. Tilman, thank you very much for your insights, and thank you for your attention.
Thank you, Jan, and enjoy the read.